Hello and welcome to Cannabis Marketing Live, all puff, no fluff. I'm your host, Kendra Losi, and I am here today. Well, today we're going to be talking about IP law. We're going to be talking about trademarks, copyrights, all of the intellectual property protection that comes up frequently and no one really knows the answers to. So to answer all those questions, we brought in an expert. We have with us today Sheila Gibson, and she is the founder of Aurora IP Law. And she's you're in Southern California, correct?
Yeah, I'm in Long Beach.
That's right. It's very close down here, just up the road. Sheila is a patent and a trademark attorney and founder of Aurora IP Law, which focuses on cannabis businesses and entrepreneurs, helping them obtain meaningful intellectual property protection. We were actually just talking, and I think you were saying that about 60% of your business is cannabis right now?
Yeah, I started out, when I started my firm, I brought sort of my, what I call legacy clients. So I was typically working in the biotech, medical device, mechanical types of inventions. But now I would say it's a solid 60, maybe approaching 70-30 split, where the majority of or I would say all of my business development and professional development has been around cannabis. So the shift is because of the efforts that I'm putting into it.
Nice. Yeah, I know that feeling. That's kind of how I started too. How did you get started in cannabis?
In about 2015, so I mentioned that I was doing biotech and specifically I was doing cancer immunology work. And as part of that, to kind of remain connected to the work that I did, I didn't want to just be a patent attorney filing documents. Otherwise, it's just paperwork, right? It's a lot of paper, it's a lot of writing. And so to stay connected, I would follow cancer patients' accounts online. So I could stay connected. I was doing a lot of cancer immunology work and just really see the bigger picture, what my role was in it, and be, connected to the work that I was doing. And one of the accounts that I started to follow as just sort of my routine following patients was Sophie Ryan of Cannabis, and that's Tracy Ryan of Cannabis, her daughter. I started following her when she was about 2 years old on Instagram. And I was just blown away by what I was seeing. And, her mom is so intelligent and so good at communicating what they're doing. And so it was educational for me, but it was also mind-blowing in the sense that I was working with world-renowned traditional cancer therapy researchers. And so I knew what was in the pipeline, well, not just what's available in the hospitals, but what's in the pipeline, what's in clinical trials, what are they in the lab with, what are they just thinking about on paper, and seeing everything that I knew behind the scenes, and then seeing on Instagram this little girl who was thriving and doing so well with cannabis, I became very intrigued. And so in about 2017, I would say, is when I really started shifting my focus. I took the Alaska bar exam because I realized that the trademark situation was going to be largely regulated by state law. And as a California attorney, you can only practice law in California. None of the other states will allow California attorneys to waive in because we don't let anybody waive into California. So I took a universal bar exam in Alaska so that I could waive into other states as it became just to have that option because it's state regulated. So I wanted, that was very clearly the direction I was going. And then about the end of 2018, when I really started to get into the business development side, my law firm wasn't sure they were supporting it. They were headquartered in Ohio, and were giving me some trouble on my efforts there. And so in 2019, I started my own law firm so that I could do the work I wanted to do.
Congratulations. I love that. I love that it came, it's so funny to me how many people come into this industry with the intent of what are the differences that can be made in the industry and in our world through the plant and what that looks like. Can you describe, before we go into, we have very set takeaways, you guys, stick with us. I'm really just curious right now. What types of clients are you working with? And by that, I mean, let me rephrase that. What work are you doing with the client specifically? Are you working on plant IP, or is it, what does that look like for cannabis clients?
It can run the gamut. So I've done everything. So I do a lot of work with brands and helping them protect their brand. either the names, also protecting their content, pictures, text, things like that. I also do a lot of work on the patent side with just different types of inventions, and those can be mechanical inventions, different processing techniques, also the plants themselves. I've gone into some grows and evaluated, just kind of gone in and walked through and evaluated their processes, evaluated their machinery, evaluated their packaging, to see what types of things are patentable in that regard. And so it runs the gamut. It's been really exciting, the work that I've done, but getting the opportunity to go in, a lot of it is education, because people don't know,
Right.
what can I patent when it comes to cannabis. And so just having that opportunity to go in and look and come up with IP strategies for the business as a whole.
I love this. And I love this so much. And partly because this interview could not be better timed. In the last few weeks, I have found 2 different websites that are just scraping all my content off my blog. And it's just trying to figure out what I can protect, how can I go after them, and that kind of thing. And I know that this type of thing happens at all levels, right? So it's not just the plant, it's it's everything that we do, what can be protected and what can't be protected. So I want to step back for a minute, and I want to talk about, as I'm talking about this, how do we talk about intellectual property like a pro? What are the difference between patents and trademarks and copyrights, and how does someone know what they need? Like, sometimes we just don't even know what to ask for or what's possible.
And that's such a good question. And when you're in, I've been doing this for 18 years, so I forget sometimes what people know and what they don't know. And so it's, first of all, don't be afraid. If you ever call an intellectual property attorney and you're like, hey, I want to patent my name, like, that happens all the time. So, but, just so you can talk about it like a pro. And when you're thinking about, I like to call it the secret sauce of your company. So this is going to be things like you have a new invention, you've invented a new method for processing something, you've invented a new machine, it could be, anything as simple as, like I said, you've invented a new packaging technique or a new packaging container, something that's new that's never been done before. That's patents. You're talking about patents. Anything that's an idea, you're talking about a patent. You may also be talking about trade secrets. So those two go hand in hand. Patents being that you would disclose the invention in exchange for a monopoly. You get a 20-year limited monopoly over, you can prevent others from making, using, selling your invention.
Okay.
Trade secret, on the other hand, that's what I call the Coca-Cola model, where we know the ingredients in that Coca-Cola bottle because the FDA makes them listed on the, on their packaging, but we don't know the specific formulation, and that's their competitive advantage over over Pepsi or RC Cola or any Shasta, whatever else you can think of. That taste comes by their specific formulation. So anything that gives you a competitive advantage that you're either trying to keep secret or you want to disclose it and make sure no one else can do it, you're talking about trade secrets and patents.
Okay.
And then on when you're talking about goodwill, so how are consumers going to know to come to you? How are they going to know to pick your cannabis brand over every other cannabis brand on the shelf in the dispensary? How are they going to know when you come out with a new product that this is also from you? So when you're talking about making sure consumers know the source of the goods, when I go and I'm looking for a certain type of product, I'm typically looking for a certain brand.
Yeah.
And oftentimes, when you're in the store, you won't do the substitute brand because you know and trust the brand. So when you're talking about goodwill, that's trademarks. And that can come in a lot of different forms. Everyone thinks of it as the name. So the name of the company, Coca-Cola, the name of the laundry detergent, Tide. So that's name. But there's a lot of other forms of trademark protection or trademarks. Companies will use things like certain colors. So if you think of Tiffany, there's a certain color that probably comes into your head. T-Mobile, there's a certain pink that comes into your head. So you can trademark colors, you can trademark scents. The scent of Play-Doh is a trademark.
Really?
Yeah, so no one else can use, so you can make whatever the generic name for Play-Doh is. What is it? Some sort of soft dough? I don't know.
Yeah, clay or yeah.
You can make it. You cannot use that scent if you make it. And so this is another way that people can, right? So now the consumer can recognize it even out of the packaging. The consumer can recognize this is Play-Doh versus this is not. Um, you can also do sounds, the sound of the lightsaber, or a lot of sounds that your computer makes, your phone makes, that the startup, this turn off, those sounds are often trademark sounds. So there's a lot of ways beyond just the name that you can be protecting, that you're using in your marketing strategy to make sure that consumers are selecting your product.
That makes so much sense, but I guess I just never thought of it. Like the ability, because you want to be able to trademark like perfume smells, right? But a product like Play-Doh, I never would have guessed.
Exactly.
That's crazy. That is crazy. But it makes complete sense. Now, can you talk about copyright for a minute as well, right? Because that's something that I think people mix up a lot, myself included, what can be copyrighted versus trademarked and that kind of thing.
Yes. Sorry, I was just texting my son to get my cat. I don't know if you can hear her in the background. She's driving me crazy.
It's life. I've got I think they just started doing landscaping outside as soon as we came in. That super close up as I look out and try and glare at them.
All of that racket is because my son is outside, because I asked him to be quiet for this. So he's outside, so you be quiet, and she's yelling at the door because she doesn't want him outside.
Oh.
Yes. So anyhow, yes. So I stopped at trademarks. I got so excited about all the different types.
That's okay. Let's go. Copyright. Right.
So the other thing, the other is copyrights. In copyrights, you're really talking about your voice. So this is, or your expression, whether you're expressing. And so these are things like your blog posts, your photographs, if you're making videos, if you're making, any. All that's required is it's fixed in a tangible medium. So once you click the shutter, the photograph is fixed. Once you press record, you finish your video, it's fixed in a tangible medium. That's all copyrighted. And so it's copyrighted as soon as it's fixed. And then you can take the additional step of registering it, which would provide additional protections or additional advantages. And so it's secret sauce, and then your goodwill, and then your voice. And a good way to illustrate it, so copyrights, you think of something you wrote, if I take this pen and I write out a whole, thing, then that's copyright. Now, if you look at this pen, I don't know if you can even see it, but, it's Sharpie brand. So the brand is trademark. And I picked this pen over, the Office Max version because I think that maybe Sharpie is making better pens than Office Max. I don't know. And then when you're thinking, okay, so this is your traditional Sharpie brand pen, but, they now make highlighters and, so now we've got, this is the brand Sharpie. It's not, Sharpie doesn't refer to the fact that it's a permanent marker. Sharpie refers to the company. And then when they have, who knows when this happened, but they decided, we can make a double-sided pen. And, one side's got the fine ink and the other side has the regular. That might be an invention. Either it might be a design patent for the design of this, or maybe the first time it was done, somebody said, let's patent a double-ended pen that has different sizes. So that's sort of a way to illustrate the difference one company might have of all their different types of IP.
I love it. That's super helpful. And it's just so nice to see it demonstrated in a pen, something that's so tangible, because it always sounds so like, oh my gosh, I've got to figure this out. I don't even know what to ask for. So thank you for that description. I really appreciate it. Now, we've talked about, you gave some great examples around specifically the patents and the special sauce, the secret sauce part, but let's talk about how to select a strong trademark. And we're not discussing this just because I also personally have a vested interest in what we can do. But how do you know, first, how do you select a strong trademark? How do you know what's worth trademarking, and how do you recommend someone get started?
That's great. So you definitely, there is a strategy to selecting a strong, and I'm glad you used that word. So a strong trademark is really what you want. And there's a continuum of marks. And so starting at like the lower end, so generic terms, you can't register generic terms. So you couldn't register the term pen for a pen or banana for a banana. It's not going to work. The trademark office isn't going to let you take that out of the English language, and they're not going to let you have a competitive edge where your competitors who are selling pens can't use that term anymore. Okay. So then one step up from that is descriptive. And so descriptive is maybe you didn't take the generic term, but your mark describes exactly what you're doing. So if I can tell from your mark exactly what you're doing, there's a chance that the mark is descriptive. It may or may not get through. And
Okay.
so, and if it does get through, it's not going to be an easy, it's not going to be an easy registration process. There's going to be an argument there because one of the refusals that the trademark office will issue is merely descriptive. So we're not going to let you, again, it's about this competitive edge. We want to let you protect your name, but we're not going to let you take language that your competitors need to use. The reason you see some descriptive marks out there is because if you have a descriptive mark that has acquired distinctiveness, so over time, and this might be, I'm trying to think of something that's acquired distinctiveness. I'm not thinking of something off the top of my head, but if after 5 years of exclusive use, and you can provide a lot of surveys that show consumers have really come to understand this mark to refer only to you and not to the industry as a whole, then you can have a registration on the primary register. In the meantime, you would go on what's called the supplemental register, which it's just what it sounds like. There's the primary register, and then there's the one below that doesn't have as many. It doesn't have as many protections that it affords, but it is still registration.
Okay.
So you want to stay away from descriptive marks. A lot of people like them because they think, oh, but I want everybody to know what I do. And my answer to that is that's what you're marketing for. Your marketing is to teach your consumer, what does Google mean? What does, that's what now everybody knows, but nobody knew when they started out.
Right.
So descriptive. Next is suggestive. And suggestive is where I can't tell exactly what your mark does, but it does suggest what you do. And that's something like Whirlpool for washing machines. So if you think of it, okay, that does sort of suggest washing machines, but you can't tell outright from Whirlpool that means washing machines.
Right.
That's a little bit stronger than descriptive, and those are registerable, and that's a sweet spot. But if you want to talk about picking a strong mark, and I'll tell you why it would be stronger. You want to be in the what's called arbitrary or fanciful. Arbitrary marks is like Apple for computers, or Dove for chocolate, or Dove for soap, where it's a generic word, right? Apple isn't a generic word. But if you're going to use it for something arbitrary, we're going to let you use it. And so those are registerable. They're also very strong. And to illustrate that, Apple has gone after anyone in their space who uses any fruit at all. So there was a company in the UK that wanted to use the mark pear for computers, and they sued them. So because it's so strong, right? Nobody has any business calling computers Apple except Apple. And it's so strong that they think you can't call computers anything that's a fruit.
Does that hold up?
That one didn't, but they have been successful in other ones. So the most recent one didn't. It finally is, getting ratcheted back a little bit, but they have been able to stop a lot of people from coming anywhere near their mark.
And I feel
where if you have more of a suggestive or descriptive mark, your scope of protection is very limited. If you have a descriptive mark in particular, you're not going to be able to go after anyone unless they're using the identical mark. And so that's why it's stronger. And then just to finish out, I know you have so fanciful, I know you're like, wait, so fanciful is made up words. Those are your Kodak, Google, Exxon. They just made those up, whether they combine two words. Again, very strong, because if it's a made up word, nobody has any business using it unless they're trying to copy you. And so, again, you get much better protection, a lot easier to register as well.
So my question is, because you were talking about Apple, and I think it's amazing that no other fruit-related terms can relate to, probably my guess would be watches, phones, and computers at this point, where I'm originally from Santa Cruz, and there was a restaurant there that called McDarma's originally was their original name, and they had a circle with the slash across the Mick, and McDonald's sued them because it was, I guess, copyright infringement, or would that be trademark infringement?
That's trademark.
Trademark infringement. And then, so now they're just Dharmas, and they've been that way for a really long time. But is it because that it's in the name, in the Mick? Like, how do you protect a Mick, right?
And there you're talking more to you throw in a famous mark, which this is a good thing to talk about in the context of cannabis too, because you see a lot of cannabis brands, especially early brands, who were parodies of famous marks. And that was because it was illegal, right? So nobody, who's going to care? We're not worried. Trademark is the least of your worries, right? And so, but when you're talking about a famous mark, they get greater protection. Part of it is because they have the money to do it, which is how Apple's been able, who's going to go up against Apple?
Right.
Who's going to go up against McDonald's? But yes, once you have a famous mark, it's a lot easier to show that somebody is trying to benefit off of your goodwill by using something very similar. And so depending on what the font looked like, because McDonald's isn't just protected for their, and I would have to see the logo to know more about it, but it's not just for the word McDonald's, but they have McDonald's in a whole bunch of different fonts. They have that, the golden arches. They have all of the variations of the golden arches they've had in their existence. All of those have separate trademark protection.
I like it. And then, so when you look at cannabis, what about something like the Girl Scout cookie strains?
Right. And so, and I don't know where they are in litigation there, but there's been a lot of litigation. So Gorilla Glue has gotten sued. They had to rebrand to GG. And in that instance, and there again, you're talking about a famous mark. And it's very obvious and intentional copying, because a lot of times they're also using their font, they're using their colors, and the thing I hear sometimes, I will hear people say, well, we'll worry about it when they sue us, or we're not worried about it, or all it will be is a cease and desist. You don't know what's going to happen. So in the case of Gorilla Glue, they were actually, Gorilla Glue was very generous with how they allowed them to rebrand. They gave them 1 year to call themselves GG, formerly Gorilla Glue. They didn't have to allow them to do that. They could have just said, no, you can't use Gorilla Glue ever again. And maybe your consumer following is fine and you can transition them easily, but maybe not. It depends on, when you're talking about a small, loyal fan base, yes. But when you're talking about, now we're a national brand, and we need somehow to get everybody to recognize us as a different name, that's a little bit different and it's a little harder. The other thing is you have to go through the expense of it, right? Now they had to hire lawyers, they had to go to litigation, they had to work out the settlement, and I'm sure they paid money. It's undisclosed because it was a settlement. Tapatio has also gone after a couple different cannabis brands who were knocking off their logo. I'm trying to think, there's been another one that I'm blanking on now. But yes, absolutely. That's definitely something that could happen. You're on mute.
Thank you. Can you hear me now?
Yeah.
I was muting myself because they're back outside. And that's something that I personally went through when I was on the board of it. I do outrigger canoe paddling, and there's one part of the season that was called the Ironman races, and it had been around for 1 million years. It's all based out of Hawaii. So let's say it had been around, 20, 30, 40 years, these races, and Ironman, the brand, came after us because we hosted the championships, and they came after us, and it was like 2 years of stress because all of us that were on the board were potentially liable. And even though we had longer duration and been using the name longer, they did not care. And they had, all the money to throw at it. And it was just, for us, it was frustrating because we're all athletes and trying to all do the same thing. And here they came along and was like, nope, it's ours. But there'd been no protection or anything around it. And like, we would have races at our championship race, and they would send lawyers or people to come and interview us to see if we were, once we changed it, because we had to change it, right? We can't, we had to change it, but then they would send people out to like spy on us the first year and see how people were referring to it and calling it and what the merchandise looked like, to see what else they could get. It was ridiculous, but it's very stressful. Like,
I'm so glad you shared that, because that's what I can't convey to clients. I think clients think, or people, not just clients, I think people think, oh, so what? They'll tell me to stop and I'll stop using it. It's like, it's not.
No, we had to get insurance, and then we were paying, and it was all to cover us personally because they were like, they're going to end up taking your house. Like, I don't want Iron Man jerks to take our house. What the hell?
Too, because you said you guys were the senior user, so you were using it first, and that was something I also have to explain. Usually they're the senior user, But
Yeah.
if somebody has enough money and
Oh
they've
yeah.
grown it bigger, then, and you don't have protection, did you have a registration?
No, it wasn't protected because it was a Hawaiian thing. It was in the spirit of the races and Ohana and all of the canoe clubs, but it was the name of the races, and that's how that first part were called. And now they're called iron races because we had to take out the man part of it, and that was the compromise.
I'm surprised they let you use iron even. So that's where, yeah, that's all part of the settlement negotiations. So
Yeah.
they could have strong armed you and said, no, you can't use any iron or any man. And.
Yeah, and it was a big lawsuit, and obviously they didn't pay for, even though as the senior users, but it's one of those things where it was just so stressful, because for all of us, it's a volunteer thing, right? So it was so stressful to be pulled into this lawsuit for something that had been around long before I joined, and long before, like, it was just awful. It was so stressful. It was so, so stressful.
Oh my goodness.
Like, I'm
Yeah.
volunteering. This is my, like, amateur hobby, right? Like, we're not racing for real. There's no Olympics we're training for.
Wow. That's so hard. But yeah, that's what happens. So it's can be as simple as a cease and desist, and it can be amicable, and they allow you, like Gorilla Glue, where, but they didn't get there without a whole lot of stress and
Yeah.
litigation and money, a lot of lawyers involved. So it's not a simple thing. So definitely, I think, um, and that's the thing that I do these interviews. A lot of what I want to convey to people is there is room to protect cannabis brands. It's not perfect yet, because we're working with a federal agency. So, I'm a federal attorney. I'm working with a federal agency. I'm protecting something that's federally illegal. It's crazy. It blows my mind. But there are ways to get at least some protection, and it's getting better every day. But like I said, it's not perfect, and and having those things in place helps so much. And there was another brand, Kiva. Kiva is actually, that might be one you're familiar with.
Yeah.
They're in litigation right now with a Kiva health brand. They do like some sort of granola bars or something. And they're in some serious litigation right now. That's not, it's not looking good so far, at least the way the motions have gone.
There's just so many things against cannabis brands that, you're right. Like, when you look at the roots of it, no one's paying attention to that intellect, to the names and the trademarks, because it's so illegal. It was so legal in the past. I mean, how we got here makes total sense, but where do you go from here? And if you're a new company, make sure and check all this out.
Yeah. And I think, the one question I get asked a lot is, well, can we even enforce it? And the total truthful answer is, I don't know. This is brand new. Like what I'm doing,
Yeah.
I when I first started doing this, I had to call a friend of mine. I was like, I feel like sometimes I'm making this up. And she's like, well, you are. Like, you're literally making it up. You're like, it feels crazy to be a pioneer in something, right? Because it's like, well, I don't know. Like, I think I'm really intelligent, and I think I'm coming up with the best strategy possible, but I can't guarantee anything. And I forgot where I was even going with this. It wasn't supposed to be a big pat on my back, but the thing was, um, you just, to have at least that protection is just so important. And that it's available. What I was saying is, these are federal agencies, and so can you enforce it? I don't know. Maybe not right now, but the thing about it, a patent lasts 20 years. And so do you want to, do I think it's never going to be enforceable in those 20 years? Absolutely not. I hope my own personal wishful thinking is that it will be federally legal in the next few years. I don't know that. I don't have a crystal ball,
Right.
but I think in 20 for sure. And are you going to want to not have protected it because it's not legal right now when you could have?
Yeah.
That's a decision. That's a business decision you have to make. And as far as trademarks are, you have trademark protection for as long as you're using the mark. So are you still going to be using the mark when it's federally legal? I would assume you were doing this with the intention of still using the mark when it's federally legal. So why wouldn't you try to protect it right now? Have that locked up, keep other people away. Maybe we can't go to court right now. Maybe we're just going to have to kind of behind the scenes. And yes, I am handling a lot of cease and desist letters behind the scenes.
Yeah.
And we're just going to have to duke it out that way until somebody, brands start getting brave enough to test it out in court. But I do think within the lifetime of the property that I can protect right now, that we will be able to enforce.
That's really good to hear. That's really good to hear, because there's so many people spending so many resources on building a company and creating products and creating services and processes and all of those things, that to not be able to protect it is huge, so.
Yeah. And that's what I don't understand. I mean, some of these brands are spending, they have to be spending hundreds of thousands of dollars creating their brands and not protecting it. And, it makes me cringe a little bit. And people get very hung up on, well, how can you protect it? It's a plant. It's been around forever. All these things have been done forever. And yes, maybe right now, everything that you see has been done before. But again, is that going to be that way forever? And I can tell you, no, it's not. Based on what I'm working on, no, I think the industry is going to evolve. We're going to see new products. We're going to see a lot of innovation. We're going to see new cultivars. We're going to see a lot of work done to fine tune, that profile, that terpene profile, or that cannabinoid profile. And no, it's not going to be exactly what it is right now. So right now, it's a little bit early. I don't even think it's early anymore. When I first started doing that, it was early to talk about IP.
Yeah.
Right now, I think it's the right time to start talking about IP and thinking about IP very seriously.
And on that note, is there any IP protection that you can obtain without an attorney?
Yeah, so copyrights, I often tell people to file their own copyright protection. So at the very least, you should be marking your copyrights. Circle C with the year of publication, with whoever owns the copyright, whether it's you or it's your company. You should be marking your photographs, marking your stock photos especially. Marking your blog posts, things like that, or easy things you can do. You can also take the next step of registering them. And copyright registration is something that's definitely something people can do themselves. It's a lot like filing taxes and less like filling out a job application. It's tedious. It's a government website. They use the most convoluted language and prompts possible. But there's not something you're going to do wrong. So you're not going to mess it up. You already own the copyright. You're just registering it. And if you get it wrong, they'll send you an email and you can fix it. So copyrights you can do yourself. A lot of people don't like to because, like I said, it's tedious. But if you have the time and you can, learn how to do it and you're patient enough to go through the website, then absolutely. And it's $65 to register your copyright. Trademark protection. I don't recommend that people do it themselves for cannabis. You can. So it's not rocket science. It's not, again, it's a government agency. You can figure out how to fill out the form. You can figure out how to describe your services. The difficulty with cannabis is you have to describe your services in a way that navigates the federal position. And that means navigating the Substances Act, navigating the Food, Drug, and Cosmetics Act. And so now I've almost become, I've become very interested or invested in the FDA because that's a lot of what I do depends on the FDA. It depends on, you have to know what is the Trademark Office accepting now. I do see some people, they will go and look at existing registrations and say, oh, well, I'm just going to use that same language in mine. And the thing is, it changes. So it evolves every day, like everything else in cannabis. So you might see one, and it's like, oh, well, they were able to register for oils. And it's like, so I'm just going to do that. Or they were able to register this type. And the thing is, if you look at the date, it might be something much older. And so for that reason, I don't recommend doing, but if you're on an ancillary service, you might be able to, depending on the ancillary service. Again, it gets dicey because even something like, let's say you were selling empty packaging, so you're just a packaging company. They will make you specify that you're not using it for cannabis. And so if they catch wind, so there is, and let me explain why. So the Trademark Office got so inundated with cannabis applications.
Oh, I bet.
I think the time I looked, there were 15,000 applications that have been filed that mention cannabis, CBD, THC.
I believe it. I'm surprised it's not more.
That was the last time I looked. And so they actually formed a cannabis section in the Trademark Office. So there is a group of examiners who only examine cannabis marks. And so if your mark gets flagged as a cannabis mark, it goes to the cannabis section. They do a little bit more due diligence than if I were to file something today for like a tire company. They will actually go to your website and see, like, is this a cannabis company? What are they selling? They will then possibly ask you to answer under oath questions about, is anything that you're selling federally illegal?
Yeah.
They'll ask you, does it have any THC? All sorts of questions. And then if you're selling something that falls under the FDA's under their jurisdiction, then they will ask you, are you selling anything that violates the Food, Drug, and Cosmetics Act? And you'll get asked a series of questions. So that's where I'm saying for cannabis brands, I don't recommend doing it without an attorney, and specifically an attorney who is well versed in cannabis and who's really invested in the cannabis regulations and understands what they're navigating around. And there's quite a few of us. There's a lot of us out there who are really invested in protecting cannabis IP.
So what we're saying is stick with the industry experts on this one. You're going to have a much better chance than if you just go to a regular IP lawyer who's probably very smart and talented but doesn't have the experience in the industry.
Totally.
That's good to know. One question I have, normally I do a speed round and ask a couple of questions, but I know we only have a few more minutes and I have one more question for you. What would you say has been and I don't know how specific you can be, so knowing client confidentiality and all that, but what has been the most like interesting story you've run into in trying to get an IP approved or get that registered?
For trademarks?
Or for any of the three. I'm assuming copyright's not as interesting.
Yeah, copyrights are they're important, but they're not as interesting. They don't get as I'm trying to think through that one. Interesting story how. I mean, I've seen some a lot of cease and desist situations that are playing out. I've seen a lot of litigation on the trademark side. There is also litigation on the patent side happening right now where somebody has a very broad claim to a method of extracting cannabis oil.
Oh.
Yeah. And so, and maybe this isn't like as, sexy of a story as you want.
No, but this is really super interesting.
But the difficulty with patents is that the trademark or the patent office, what they do is, so we describe the invention, we try to claim it as broadly as possible, no matter what invention. If you came to me with a new cookie cutter, I would try to describe it as broadly as possible. I'd make it into a shoe if I could. And so that's what patent attorneys do. And so that's what everybody who filed cannabis very early, that's what they did. Well, then what the patent office does is they do a search and they look for prior art and they say, well, no, what you've described is the same as this thing that already exists. And then you amend around the prior art to limit to something that's much more narrow in scope and probably more in line with what you actually invented. With cannabis, when they go to search for prior art, there is no prior art because nobody was writing this stuff, right?
Yeah.
You weren't saying like, here's a new formulation I just made. Here's how I extract cannabis. Here's how I,
Yeah.
And so initially, some people, and I don't know if they were good actors or bad actors, whether they were just exploiting the situation or this is really what, they're doing, but who filed these very broad patents and were able to obtain them because there wasn't any prior art. Mm-hmm. So I didn't think that they would assert them, but they have. There's one that they are asserting now. And what I hope will happen is I hope that the industry will rally around this defendant because and really help them. There's got to be some prior art, right? The examiner is very limited. They have 3 hours to examine an application. So he or she can't scour the internet and try to find that, this has already been done. But if the defendant can invalidate the patent in court, it's invalid as to everyone. So that patentee holder can't assert that patent anymore against anyone else. So what I hope to see happen in this case is I hope to see some money poured into that, some resources poured into that and pulled together to really try and take down that patent. It's very broad. It's way too broad. And at least get it limited down to something more respectable of what they actually invented or and are entitled to protection for. But right now I think it's based on like 95%. It's like a yield. It's a very broad claim. So yeah.
It sounds like that's something that would actually benefit the entire industry to have that not enforced just for future, right? If it helps someone, it's going to help a lot of other people too.
Totally. So what I think is going to happen is I think there's going to be these very broad patents that are issued. They're going to be a nuisance. We're going to have to go through a lot of litigation. I hope that the community, the industry will really rally around and kind of flush out the like trash patents.
Yeah.
And then we'll to, and that's just because there wasn't a baseline, right? Every other industry started somewhere and then it just kept building. Here it started, kept building, and then all of a sudden people filed patents right in the middle.
Yeah.
So we just got to flush out those nonsense patents, and then we'll start to see that the actual legitimate patents come through, and it'll be like every other industry. There'll be patent litigation, but I think the initial patent litigation we're going to see is going to be a little bit troublesome for a lot of people.
Okay, that makes sense. Yeah, surprising. So as we wrap up here, what would be do you have one piece of like the main advice that you give people that you'd recommend for someone looking to get started and figuring out if they need to get a trademark or get some IP protection on their secret sauce?
Yeah, so if you have an invention and you're thinking about patents and trademarks, the key piece of advice I could give you is make sure you talk to an attorney before you disclose. Once you publicly disclose, you start to lose some rights and some abilities to even protect it. So if you publicly disclose, you lose your foreign rights. So you cannot protect any longer outside of the U.S. Inside the U.S., you still have 1 year after you disclose, because the U.S. has a weird grace period. Other countries don't have that. So very, very important before you publicly disclose to anyone, decide, am I even thinking about patent protection? Do I want to explore it? Or is it a hard no? If it's a hard no, go ahead, disclose. If it's I'm not sure, talk to an attorney first, see if it's protectable, evaluate your options before you publicly disclose it. On the trademark side, I would say protect your mark as early as possible. And you can file marks as an intent to use. So let's say you have a concept for a brand, but you haven't developed the brand yet, or a company, you can file it as, I'm not using it yet, but I have an intent to use. That will go through the regular trademark process. And then instead of receiving a registration, you'll receive a notice of allowance. And that notice of allowance will set a 3-year deadline to show use. You may have to pay some extensions, but if you're within the 3 to 4 year window of being ready to use your mark, and especially if you think your mark's really cool and you want to make sure no one else uses it before you do, and or uses it, then definitely start thinking about trademark protection.
Fantastic. This is super helpful. Thank you so much for being here. Before we go, can you let people know where they can contact you if they have any questions or want to discuss any of this further with you?
Yeah, so I have a website, www.auraIPlaw.com, and that's Aura, A-U-R-A, like your aura. So Aura IP is in intellectual property law.com. My Instagram is the same, Aura IP Law. And on my website, on the Contact Us page, you can schedule a consultation right there directly for anything patents, trademarks, or copyrights. And then I'm also starting a YouTube channel coming probably, yes, I think I have another call today to start talk more about it. But I would say by the end of this month, maybe middle of next month, I will start coming out with weekly YouTube videos, just talking about all different aspects of intellectual property and also IP specific to cannabis. So those are the best places. I'm also on LinkedIn and I'm on Facebook, but I clearly don't really know how to use it very well.
So we'll look at website first, Instagram second, and then YouTube coming. I love YouTube. YouTube's great. Anyway, thank you so much for being here, you guys. I will drop Sheila's contact information in the comments below as well, so that way you won't have to do some Google searches. You'll be able to reach out to her directly from there. And thank you so much for being here. I really appreciate all of your knowledge. It's been really informative having you. So thank you very much.
You're welcome. Thanks for having me.
Of course. Thank you guys. Have a great time, and we'll see you next month. Bye.
Bye.